There are new developments in the case of a Greenville bar owner suing Governor Roy Cooper in the North Carolina court system. Joining us now for an update on the case called Waldron v. Cooper is Jessica Thompson. She's an attorney with the Pacific Legal Foundation and the attorney for the plaintiff in this case. Welcome back, Jessica.
Thanks for having me, Mitch.
So first of all, remind us, what was the original purpose of this case that we call Waldron v. Cooper?
Yes, so Crystal Waldron is a co-owner of Club 519, a private bar in Greenville, North Carolina. And a private bar is just a bar that serves beer and alcohol like any other bar, but they don't serve food. And so they were forced closed by Governor Cooper's orders for almost 11 months, while bars across the state, inside of restaurants, breweries, wineries, distilleries, even bottle shops, they were all allowed to open. And so we were suing to allow them to open under the same health and safety precautions and to ensure equal protection of the laws under the North Carolina Constitution.
And you actually had a chance to take the case before a Superior Court judge and argue against the attorneys for Governor Cooper. What was your sense of what Judge Gayle in this case was thinking about your suit?
Sure. So the attorneys really advanced a novel excuse for treating the private bars differently than all the other bars that were open across the state. They advanced economic favoritism. They said that private bars don't commit as much money to the state GDP, that the state hasn't invested resources to attract bars to the state in the same way that they've invested resources to attract breweries and wineries. And the judge wasn't satisfied with that evidence. He was looking for a health or public health-based reason to distinguish between these bars, and the governor's counsel could not offer any.
Yeah, in fact, I was listening to this hearing, and I remember at one point that we're talking about Judge James Gayle, who was talking to the attorney for representing the governor and saying, I'm begging you, give me some evidence that distinguishes these private bars from the other bars that have been allowed to reopen. And I didn't get the sense that he ever got the evidence he was looking for.
That's right. And I think that's because they can't provide any evidence that distinguishes between these two bars because they're similarly situated businesses. And under the North Carolina Constitution, you must treat similarly situated businesses the same.
Since that hearing, though, there have been changes. Governor Roy Cooper's latest executive order has allowed private bars to reopen to some extent. So now you have changed your suit, I guess under an order or a suggestion from Judge Gayle that you amend your complaint. What's new about the case?
Yes, so we are focusing on the governor's authority to issue these executive orders because the arbitrary treatment of bars is still continuing. They are still open at a different capacity level than the bars across the state. And in fact, the governor could make the decision tomorrow to completely close private bars again. And so we are challenging his authority to issue such executive orders by going directly to the Emergency Management Act and challenging whether or not it violates the state's separation of powers clause.
I'm in danger here of showing that I'm not a lawyer when I talk about this, but from what I understand, one of the differences now is that when you challenge the constitutionality of a law, sometimes it could be as it's applied to a particular plaintiff, which is what you were really working on first in this case. Other times, it's what's called a facial challenge, that the law itself is unconstitutional on its face. And in that case, you have a different setting. You have to go before a three-judge panel. This is what you're doing now, right? You're asking that this case go before a three-judge panel.
That's right. So we've asked Judge Gayle to ask the Chief Justice of the North Carolina Supreme Court to appoint 3 judges that will hear this case, and we are challenging whether or not the Emergency Management Act delegates too much legislative power to the governor. And in doing so, it takes away the constitutional authority granted to the General Assembly, the people's representatives, to decide policy for the state of North Carolina.
Back in your original complaint, and I assume this is still true in the amended complaint, you talked about the fact that at the beginning of this pandemic, when people didn't really know what was happening, the governor steps in, has his executive orders, but now a year later, basically, the General Assembly has had plenty of time to step in and play the typical legislative role, but the governor, through these orders, doesn't allow the legislature to do its job.
That's right. And as the state of emergency, this health pandemic has continued, and the governor has continued to issue executive orders, we start to see what broad power the statute has given him, because there's no temporal limitation. He could continue to issue restrictions on when businesses may open, close, and when they may open, under what circumstances they may reopen. He can continue to do that in perpetuity, forever. And that's not what the North Carolina Constitution set out for North Carolinians.
So the original complaint on behalf of Crystal Waldron and Club 519 was, let us reopen under the same circumstances as every other bar that's already reopened. Does your new complaint have that same goal? Or it sounds as if there's also this larger goal of, we got to strike down the Emergency Management Act, or at least change it so that it meets the constitutional requirements.
That's right. That's right. It really focuses more on, does the governor actually have the authority to dictate well over a year into this pandemic, how businesses should operate, where people can travel. If we think back to the beginning of the pandemic, he determined what businesses were essential and non-essential, and that included elective surgery. So this is just incredibly broad power over North Carolinians' lives, and we want a court to determine if that is in fact constitutional.
Jessica Thompson is an attorney with the Pacific Legal Foundation representing Crystal Waldron and Club 519 in this suit against Governor Roy Cooper. Thanks so much for joining us.
Thank you for having me, Mitch.